You are with me, Miriam Angel and Salim Barisa. And you know what Tuesday? It is our Legal Tuesday. So we always get a legal expert, mostly an advocate of the High Court, to talk about matters that we might not explain in detail on our own. And in studio today, we are joined by Bennette Nzamba. She is an advocate of the High Court. Bennette, good morning.
Good morning.
How are you doing?
Very well.
Karibu sana.
Thank you, Asante sana, to have me here.
All right. Now, we've seen many layoffs in Kenya recently from media houses. This is happening in a lot of media houses and also just to different companies, different NGOs and different tech firms. Could you explain in simple terms what redundancy and retrenchment legally mean under the Kenyan employment law?
Okay, thank you. Redundancy is covered under the Kenyan Employment Law, Employment Act, 2007. It is basically where an employee is rendered that they have been terminated, not because of their wrongdoings or anything, just because of the involuntary nature that the work is no longer existence, or there's some restructuring of the company, and this is usually occasioned by the employer, not the employee. So the job is rendered done, like you no longer are there. And then retrenchment. Retrenchment also basically is a form of redundancy. And in this one is it's where it is also encompassed in redundancy under the Kenyan Act, because it is not there in our laws. It means you will lose your job because of financial constraints mainly. So in redundancy, we cover, there are different terms that can be used to render someone redundant. This is like, for example, companies will use, we are reconstructing the company, we are reorganizing, or we are laying off people, and then retrenchment. So all of them are under redundancy in the Kenyan law. So this means when you're trying to render an employee redundant, or you want them now to be out of employment, it should be very specific. Like, one, you need to have there has to be new development in technology that will then make sure that this person no longer will serve you. And then two, the company could be, winding up. It cannot sustain its business anymore. So the bosses or the company itself might decide to just lay off some people due to redundancy. Those are some of the issues. But then,
so meaning an organization has to show that they cannot sustain an employee.
Yes.
Okay, and through that is pretty much financial constraints. Because what I always hear is the company, we're unable to. It gets to a point where maybe you've worked at an organization for some time and they haven't paid you for a good number of months, right?
Yeah.
And then most times what you see is a memo. And there's like a notice of this is about to happen. We're going to do
in 1 month's time.
In 1 month's time, right?
Yeah.
So let's look at the legal grounds. Under what circumstances is an employer legally allowed to declare employees redundant? You've said the first one,
when there is new technology that would not allow you then to have this employee. Let's say, like, for example, the way people are now in having AI. So you would decide then, let me start using Gemini, ChatGPT, instead of having a legal researcher, for example. So now that legal researcher's occupation will then be rendered absolute.
Yes,
you see. But then remember, you cannot render an individual, someone, redundant. You render the position that they hold redundant.
Okay. So you render the position that they hold. So if AI, if technology takes over my job, so right now penye niko hapa niseme
they start using Siri.
Una
robot.
Yes. So my position is rendered redundant. But Mimi, I have not been rendered redundant.
Yes.
But I'm the one who's affected.
Explain.
I'm the one who's affected.
Yes.
I'm the one who's losing.
you're the one who is affected, yes. But then, because you see, when you're talking about redundancy, it means that you have not done anything wrong.
Okay.
That will, like, for example, it is a form of termination. But then when you look at termination on the other categories, this redundancy is covered under Section 40 of the Employment Act.
Yes.
But now when you look at the other forms of termination,
Yeah.
and Section, is it 40, 46, 48, they show you that, there are procedures when an employee is caught up in a misconduct, so that is when the employee is at fault, then the termination comes automatically because of these things that have been laid out.
Yeah.
But now in redundancy, it is the employer who comes and finds out, for example, let's say if it is truck drivers, you're a truck company and you decide that these lorries are not giving me, as much. So now I'm deciding to move from lorry drivers and I want minibuses.
Yeah.
So now when you do that, you have to call all the employees who are in that department, the lorry department, and you ensure when you discuss with them and tell them that now that is called the consultative meeting. I think we'll get there, the roles of an employer in this.
Yes.
When you have to call them and tell them that this position will not now, we will not be dealing with this position henceforth, and this is the reasons why, and you give them alternatives and all that. And then you say you will now move to this other form of business that you want to start. So you have to lay off all these people. If you as the employer, you then remove this person because you terminate them on account of redundancy, and then you employ someone else as a truck driver again, then that is an offense.
A problem.
Yes, it means that position is not rendered redundant.
But what do we always see? And if yes, kwa ground, tuje kwa ground, right? So kwa ground virtually different. So what happens kwa ground is I will render Miriam redundant and get an affordable labor. I don't want to say cheap labor. And get, so if Miriam, let's say, was getting paid, let's give it an approximate of maybe 100K, right?
Yeah.
And I render Miriam redundant. And then later on, Miriam sees somebody else in her position.
Yes.
And then you find that now we are cutting cost. So in cutting cost, this person gets like half what Miriam was getting paid, or even, let's say, 30K, or even...
That is wrong in itself.
So I can sue the organization.
Yes, exactly. You can sue the organization because your position has not been rendered redundant. They were trying to constructively redundant you so that you just come out because they cannot sustain your pay schedule. Yeah. So that is wrong in itself, and someone is supposed to go and then file a claim in court or even report to the labor officers. Then there is a procedure. Now, maybe if we may talk about...
Before you go to the procedure, let's talk about employer obligation, right? The specific steps that an employer must follow in carrying out redundancy to ensure the process is fair and lawful. I think you've mentioned one where you have to call the team that you want to render redundant and tell them why.
Yes.
What else?
Yes. So that is a consultative meeting.
Yeah.
In the consultative meeting, you have to call the entire department. In practice, how people do it, it is important to have it minuted, have a minute, and then let the people that you have called also just sign against the minutes that you've given them the reasons, you've explained to them. It's like nakubembeleza nikufute.
Yes.
So it has to be, because if you don't do that step, it will be a miss whatever for you. It will be a wrong process for you. The process will be flawed. Yeah. So when you go to court, that will hold you accountable. So you have to explain to these people, let them sign that they attended the meeting, you talked to them. Then 2, you must serve the notice under Section 40. You must have the notice telling them that, effective this date, your position will be rendered redundant on account of maybe new technology, or on account of business reconstructing, or on account of we don't need this position anymore, and all that. And then you must tell them effective from which date your position will be rendered redundancy. So it has to be very detailed and explained. And the notice period should be 30 days. So if it is not 30 days, then it means yes, you can pay them, notice in lieu, but that's process already imeshaanza kuwa poked if it is not the notice period is not served in accordance with the law.
Yeah.
Okay, then so that is the notice period. So after that, then you go you go about now the selection criteria. Yes, so selection criteria also has stages. One, you need to have seniority in time. What to consider in selection criteria. So seniority in time is mainly the principle of last in, first out. So if you are employed, let's say Barisa came in before you, and then you came in, you were employed the last after him.
Yes.
So when we are declaring this position redundant, then it has to be you first who is going out. But then there are still stages. I'm going to explain them. So that is seniority, because you need to still maintain the sustainability of the company. The growth, and this person has been with you for many years, so they know how you go about your business, how you continuity of the business and profits. So that is one, seniority in time. Then two, the skills. So is this person, this group of people that you want to render redundant, their skills, is it still in line with your company's new values and principles and objectives that you are now conforming to? And then or had their skills over the past years good, or have they been bringing you more profits and all that? So those are the things that you need to consider. And then reliability. Is this person reliable from their records? Do they come to work early? I'm just mentioning, from these are some of the things that you need to look at. And then the other thing is ability. What do they do? So those are 4 things. We've talked about seniority in time, ability, skills, and reliability. So when you look at these things, they will help you. You have to come up with a matrix, a form of matrix, where you will now gauge all the employees that you need to render redundant. You will have measure them on a scale of maybe 1 to 5 or something, and then you put for each and every employee specifically, so that you see what is the score at the end of it. Like Miriam, how much, according to these things that we have mentioned, what is your score? And Barisa, I keep forgetting you. Barisa, what is your score on this?
You can use
Salim. So what is your score on the 5 things, on the 4 things that we have mentioned? So those are the things that we need to look when you are doing the selection criteria. And it must not feel like it is discriminatory. So that is why it is a very sensitive process to even think of rendering someone redundant or even a whole team. Then the other thing is we've talked about the notice, selection process, consultation. Then if it is, you need to also pay them, because this person essentially did not think that I will lose my job.
Yes.
You as an employee, you are very comfortable. You think you're here for a lifetime until you get to your retirement age.
Yes.
And then all of a sudden you're told, oops, you have to go home. So this is already stress in itself. So then as an employer, you must then pay them severance pay. That is very key. This severance pay is then paid for the 15 days of every full year that has been worked.
15 days?
Yes. So if you've worked for, let's say, 5 years, so a full year, you'll be paid 15 days of that, and then for the 5 years, okay? 15 days only for every full year worked. Okay, so that is severance pay.
So that's now for the 5 years that you've been there.
Yes.
So you paid for 15 days. So let's say let's just make it practical. So let's say somebody's income is 50K.
Yeah.
Right?
Yeah.
How would that look like in 5 years?
Okay, in 5 years, you need to calculate it as 15. 15 now divided by 30, of course. Okay, 15 times the 50,000. Then times, I don't know if I'm getting the math right, times the number of years worked. 5.
Oh, it's 15 days.
Yes.
And then times the number of years.
Yes. Plus the salary that you get per month. times the salary that you get per month.
15 divided by 50 times 5.
No, not divide.
Okay, all right.
15 times 50 times 5.
15 times 50 times 5.
Is it?
That's 3,750.
Yeah, I think so.
Did I get it right? This math is not
Mnapigaje
my
hiyo
thing.
hesabu?
Wait, I mean, Ashanga.
Hesabu imetulemea, ngoja tuangalie.
15 times
Wanahabari
50
na
times 5.
mawakili.
Hapana, ngoja.
Math.
15 times 50 times 5. I'm getting 3,750. And let's calculate. I'm going to find
okay, but hapa, are you going to see 15 days of the month salary? Ama ni hiyo 50,000? Because ametoa mfano wa 50, right?
Yes.
Yenye per month alikuwa analipwa 50. So unalipwa 15 days. That's not 50,000.
Oh, no, that's not 50,000. It's now, 15 days for a full year.
Yeah.
Okay.
Okay, twende pole pole. Umesema
Mwalimu wa math.
Huko historia hisabu. No, we need to be clear hapa, like the law.
Yes.
Umesema unalipwa 15 days. Per month, Miriam ama Barisa analipwa 50,000.
Yes.
So hizi 15 days unalipwa how much? Is it the 50,000 or inapungua?
Hapana, inafaa ipungue.
Inafaa kupungua.
15 days
Yes.
divide by now 50,000 unalipa per month. You divide it by the number of
So ni
working
25.
So
days.
25K.
Yes. The number 50 divide by 30, because 50 you are paid after 28 30 days,
Yeah.
and then times.
So now it's
15.
50 divided by 30.
Yes.
Okay.
So you unapata 1,666.
Yes.
1,666 times 15.
Times 15.
Times 15.
24,990.
And now
Mwalimu wa math, we're getting there.
tunaelekea huko.
So 24,990. This person gets, so if this person has worked for 5 years, now we multiply that by 5.
Yes.
Tanapata 124,950 for the
Exact.
severance pay.
Yes.
Alafu nao sasa umekuja ukasema kuna na za mwezi.
Sasa ile notice in lieu
Ndio unalipwa hiyo.
unaongeza pia hapo.
Ongeza 50.
Kama notice in lieu lazima
That's the
ulipo.
1 month.
Yes, notice 50.
Okay.
Ongeza
Plus
50. Yes.
And then plus any leave days that you have not
Zenye
been
ziko
paid,
hapo.
unpaid leave days
Oh,
for
okay.
that year.
Okay.
So
Yes.
then this person now gets like 129,950.
Yeah.
Okay.
Yeah.
The math has math.
The math has math. So that is the obligation for the employer.
Yeah.
So if your employer does not honor this, and we see instances where you're made redundant, you don't receive the severance pay,
Yes.
you don't receive
Your monthly.
Your leave days.
yes, your leave
na
days.
month.
You know what they do is
They'll give you the notice.
they'll give you the notice.
Yes.
They'll call you for a discussion to tell you
Yes.
that this is happening. You'll sign certain things to show that I attended this consultative forum. Wait, it's one way, right?
Yeah.
As once you've signed, they'll say we will clear your arrears.
Yeah.
We shall communicate. Then the moment you leave, and they even ask you to submit your badges, your tag, your work things.
Yes.
Kila kitu. They lock you out of the work email, right? A lot of Kenyans can testify. They lock you out of the work email, and then
You're out there.
you're out.
Huwezi access.
So now you're stuck.
So what we recommend is, every time you're served with anything from your employer, I mean, you have the right to get legal advice. So don't sign anything before you have the right to say, let me first consult my wakili on this. Listen to that. Don't sign anything before you consult.
Okay.
Yeah. Even you can, if you don't have money for counsel, then you can still go to the labor officer and consult before you put your signature on anything. Because once you sign, it means you're already accepting to the terms that they are giving you there. You see? Because they will say, see, he signed this.
Yes.
And then always from the onset, we say, keep your documentations. Have your contract, file it. Have a file, your file at home. Keep every document that comes from your employer. Because you never know when the side goes whatever, crazy on the other side. So you need to always have a file and keep all the documentations. So here you must know what are your rights. essentially you have a right to fair practice under the Constitution. You have a right to fair labor practice and employment practices. So when you as an employee get this, first you can consult. Then after consultation, you then go back and say, okay, this is what I have, and see how you can, go through it. And yes, you can also have a representative sometimes, but I know how the pressure is, so it is almost irregular that you will not have someone there with you to guide you.
Yes.
Yeah. So when this happens, there is always a backup. Yeah. Then what else? Have your documents, always consult with your counsel, and then you must don't be fast at signing documents that you don't know.
Kuna swali Miriam hapa lazima tuambiane. Hizi vitu tumeziona kwanza kwa the media. Tumeziona na zinaumaga sana. Tumepiga hesabu ya hiyo yenye amesema, hiyo math.
Yes.
But kuna wale watu wenye before hata hiyo story ya redundancy, mtu hakuwa amelipwa for a period of 8 months,
almost a year.
Almost a year. Yeah. Halafu out of the blues, mtu anakuja na note hiyo memo, sijui ni notice ya redundancy ama hiyo umesema realignment ama nini,
restructuring,
hiyo kitu.
Redundancy and retrenchment.
Nimesema realignment we
mwalimu wa English tukisaidia sana.
Anakuja na hiyo. So hapo ukishapata hiyo na unadai a year, 6 months, 4 months, 5, what do you do?
Bado kuna kesi. So that then that changes from redundancy to unfair termination. But now the court will always look at it, because there is already here there's already a trend that you have not been paying me for the last this number of months, and then you slap me with a redundancy notice. Like, really, what were you planning? You see, so it becomes it can be construed by the courts that this was already preconceived, that we want to terminate this person, but then let's do it in a way that will save us, because under the law the employer is allowed to have redundancy. The employer is allowed to do that. But then it must be, as you were saying, it must be fair and procedural. It must not be discriminatory. It must not be a way of, getting this person out of employment because we don't feel this person is good for us anymore. So when now redundancy, because when you go back to court, they usually put it into tests. They look at the procedure and they look at all these things. Was the notice served in time? Was the selection process done in the proper way? Was there a consultative meeting? Because if none of this is aligning, then the let me not say the charge, the claim then shifts to unfair termination. And unfair termination is also covered under the Employment and Labor Employment Act, And now the compensation in unemployment, there are so many other benefits when you're terminated as unfair termination, but then the maximum of compensation is up to 12 months compensation for because you fired me unfairly, you see. So that is going to be a more detrimental mishap for the employer, because you left this and then ukafanya unfair termination in the disguise of redundancy. So now you're slapped with among other benefits, 12 months compensation for this person.
What about instances where somebody has gone through, yes, you have not been paid by this organization, and then they render you redundant, and then you decide, fine, I'm going to seek legal action, right? And then through that process, and I'm trying to see why most people don't even go to court. First of all, somebody might say it takes longer. And then the other thing is then there are employers who outrightly just ignore.
I know.
Court orders.
Yes,
they just ignore court orders. So what does now one do? Do you forgo that, or do you still pursue, and for how long?
No, you see, when you feel like your rights have been infringed, we always have the courts for redress, and also under the Employment Act, there is a need for negotiations or ADR. It also advocates for settling matters out of court. Yeah. So if you as a person would go to the labor relations if you feel just to consult, or go to an advocate, that is allowed. Then if you meet with your counsel and then they advise, we can try and solve this matter out of court. If they don't, if they don't, then proceed to court. I think I'm an ADR practitioner, so I would always advise, let's try and settle out of court, because it is fast, it saves on time. We're not saying that nowadays they try in court, but there is a process in court.
And how many employers are willing to sit down with their employees and go the alternative dispute resolution way?
Okay, the statistics are a bit low, but then we are in progress. Of course, you wouldn't go back to this person mwenye amekufuta kazi. You still have uko umekasirika bado, uko na makasiriko like hapana, mimi sitaki kuongea na huyu mtu. He has taken away my bread and butter, then what? Why should I talk to them? But in like for mediation, for example, you will discuss over a number of times, at least 60 days. Then you will get to know, it's not bad. And then at the end of the day, I'm getting this money, but at a shorter period. Then if we go to court, it might take a bit of time because of the court process. When you go to court, yes, you must file your documents as the claimant. In employment we call them claimant, and then the employer will be called the respondent. So it is a process. You go to file your documents, then you wait for the other side to respond. So we take a pre-trial date. Then they say that they have just received the documents, and that's what delays. They have received the documents and they need to put in their responses. Then they come in later after a month. And then later on we take a date for now mentioned to take a hearing date. The hearing date, Mara court is not sitting at times. Court is on training. I'm just saying what
the words that you use in the corridors of court.
What makes the delays? But essentially, in civil claims, it's supposed to take approximately six months. But we don't achieve this because of this. So many matters that maybe our judiciary officers have, and we file so many cases in court. So sometimes you would find it can take a year or two.
Where are we seeing an instance where the law sounds very clear, but where are we seeing instances where employers disregard employees' rights?
Let me not say because of selfish needs. But employers disregard this because also
I can see that they can get away with it, and it
not
does
really. I am an employer myself, but maybe it is. I would think because sometimes they would feel that they have done everything in accordance with the law. So they feel like there are no loopholes because they have all the documentations essentially. But under the Employment Act, the burden is always put on the employer. So it is you as the employer to prove that you did not terminate Salim wrongfully or unlawfully. So the burden is on you. As the employee, you would not even need to prove anything. That is the best thing about employment law. You just need to be there and say, I feel this redundancy process was not done according to the law.
And now stick up.
and you
you have nothing to explain,
provided you have
of course you have to explain the procedure through your advocates that the selection process was not done well, because I feel I was employed before Salim, and mimi ndo nilifutwa wa kwanza. Salim akaachwa. So mimi nina right ya kubaki pale pale kazini. You see, that is the selection criteria. And or maybe Salim doesn't have a degree in communication, and me, I have even my master's in communication and journalism. I don't know how it's called, something like that. And I wonder why, so you feel discriminated. Yeah.
Okay. You mentioned something earlier on when you talked about business constructing as one of the reasons why organizations need to do redundancy. Now, under business constructing, and I'll take you back to when you said that when that position is rendered obsolete, right? And instances where they're doing business constructing.
Reconstruction.
Yes. Can a position be rendered obsolete? Ama, we're just saying we're reconstructing and then we still hire another employee for that said position.
Okay. Then it needs to be, it's the same thing as redundancy, because those are the company law terms. Yes, the position can be rendered, but if people usually reconstruct and then bring in new terminologies for that job description, for that office, for that job description. So if the employee who was rendered redundant then has proper legal advice, they can come back and say, Palevo, they removed me because I was a tea girl, but now they have brought in someone else and called them a cleaner. But this person still does my job description. That is also a form of reconstruction, because we have the same outfit, but now different names. So it can still be rendered. It depends now with if they don't change the terminologies. I mean, if they have different sorts of jobs that do not include, your job description entirely, then that is okay. But if it is a change of outfit, same description, you can challenge that in court.
Okay. And then also now when we look at redundancy, because you said you start now, you start with Ukuchini, whoever came in late as you reconstruct. But we also see instances when people do redundancies, especially if it's financial, they always start by cutting off those people who earn more money. Like if Salim takes away the big bag, if the managers take away the big bag, those are the people who most of the times will leave the organization. How can somebody, an employee in this case, protect themselves from being a target?
Okay, now those are the alternatives to redundancy. There has to be consultative redundancy. Let's talk about our salary pay cut. You can talk about that. If you explain, if you have a consultative discussion with your employee as an employer, that you've seen our business is not running well, can we during COVID, you remember during COVID people had salary
pay cuts,
pay cuts, and that was understood because even the government did the pay cut thing. So it is really understood if you have provided we have agreed. If the person doesn't agree, then there's no option. You as the employer, you have to still keep them there and survive, and also look at alternatives of what you can do to have them go on, which is crazy. It will be crazy on your part as the employer. I mean, the other alternative is then maybe having time schedules for working. Instead of them working from 8 to 5, then you can reduce the time schedule and say, see, now we don't have so much work. I don't want to render you guys redundant, but then we need to now work in shifts. Let's work 4 hours a day, and all that. So those are some of the alternatives that you can go about instead of rendering someone redundant.
Okay. And now, finally, what practical advice would you give to an employee facing redundancy and to an employer considering it?
Practical advice for the employee. 1, you need to know your rights. Yes. Have have your documentations
Yeah.
in place, then ask, of course, when you feel this person is not, like the things are not going as is, because essentially you have a right to be there as an employee, as an employee. And when you have your when you know what your rights are, especially in terms of the redundancy package, you'll be good to go. So if you're rendered redundant, then you need to know that I must be paid for my notice. I must be explained of the procedure of redundancy, and it must be very fair and not discriminatory.
Yeah.
Yes, the selection process. Did this person even consult us? And who is going? Is it me only? Is it my position only? Are they replacing my position with someone else? Because I was getting a higher salary and they need to get someone who is getting something low. So if this position is abolished, it should not have anyone else. That's the thing. Yeah. Then in my package, do I have my severance pay? Yes. If you don't have those are the things that will lead you to court. That is for the employee. Now, for the employer, ensure that you follow the due process. Yes, you are allowed to render persons or the job itself redundant, because you have a right to reconstruct, bring new skills, technology. Yes, your business is not doing well. You need maybe to shut down and start something else. So you have a right to do that. But then, did I follow the procedure? Was I fair? Was I, whatever we have just discussed, the selection process, make sure you have a proper consultative meeting, get minutes, let people sign on the minutes. And then 2, have a proper selection process, the ones that we have talked about, seniority in time, that is the last in, first out. Okay. And then have it's called LIFO principle. Then have pay notices, so that you are within the law, you are not caught up. Then of course, give the package, the redundancy package. Yeah. So those are the things. But for employers, you must really be keen with the process, so that you don't have to fall a victim again in litigation. Yes. And for employees, just follow. You be there, know your rights. I mean, I'm supposed to be working. My contract says I am here till this time, or when, or yes, I have not. My contract is open. It doesn't have a termination time. So then, why am I being rendered redundant? What are the options? What are you giving me? In the consultative meeting, that is where you now also give them options. That we can have you, but with this salary cut.
Yeah.
We can then maybe we will move you to another sister company of ours. Such things happen in the consultative meeting.
Okay. All right. Thank you so much, Bennette. Thank you for making time. We have been speaking to Bennette Nzamba. She is an advocate of the High Court. Well, we'll be right back.